What is the doctrine of ultra-wireless memorandum and articles and memorandum of association and article of association difference? Today we will discuss in the name of Allah who is most merciful and beneficial doctrine of ultra-wireless memorandum and articles. The term is derived from two Latin words ultra and virus. Ultra means beyond, any virus means any power or authority. Ultra virus means doing an act which is beyond the legal powers and authority of the company. In corporate law, ultra vires describe acts attempted by a corporation that are beyond the scope of powers granted by the corporation's object clause, article of association, or in a clause in a bylaws in the law authorizing a corporation's formation or similar documents. Acts attempted by a corporation that are beyond the scope of the character are void and voidable. What is the difference between Memorandum and Article of Association? Memorandum and Article of Association. Memorandum of Association, it is the charter of the company setting out its constitution. While we talk about the Article of Association, it is the bylaws of the companies for the internal administration. Memorandum of Association, it lays down the conditions of incorporation and defines the limits and powers of the company. It defines on the behalf on the other hand, Article of Association, it defines the right and duties of the directors, members, etc. Memorandum of Association, it states the objects for which the company is established, while the Article of Association, it states the rules or manners of carrying out the business as stated in the memorandum. They cannot be contrary to powers and objects set forth in the memorandum. It is Memorandum of Association. Memorandum of Association, it is a compulsory without which incorporation is not possible. Its preparation is not compulsory. The public compulsory for the public company table A will be applicable in its absence. If we talk about the Memorandum of Association, it governs the external relation of the company, while Article of Association, it defines the relationship between members and its management of the company. Internal administration is its main area. We talk about Memorandum of Association. We are not talking about the Article of Association. We talk about Memorandum of Association. It is primary and fundamental document foundation for the company's structures responsible for the company's birth. It is unchallengeable on statutory matters, while the Article of Association, it is a secondary, subordinate, subsidiary document. It should be read and understood in light of the memorandum. It complements or supplement of memorandum. While memorandum of association, it lays the area or scope of the company beyond which the company cannot go. It lays down the area or scope of the company beyond which company cannot go. While the Article of Association, its activities must be confined to the area and scope of the memorandum. All the articles with the ultraviolet articles and intraviolet memorandum are not void and can be ratified by a special resolution. While the memorandum of association, it can be altered only by a special resolution and subject to the sanction of the court or central government as case may be. While Article of Association, it can be altered by a special resolution and the sanction is not necessary. Okay. Talk about the Article of Association. It is very most important question. Mostly students ask me what is the Article of Association. I already told you what is the difference between article and memorandum of association. Now we will discuss the what is Article of Association. Memorandum of Association we already have discussed last video. So there we will discuss the what is different, what is the Article of Association. Article of Association section 36 to 45 of the Companies Act 2017 deals with Article of Association. The Article of Association are the internal regulation regulations of the company. They define the rules for the internal management, the relationship between the company and its members, and rights and duties of the shareholders and directors. If the memorandum is the constitution, the articles are the bylaws. We can say that if the memorandum is the constitution, while the articles is the article of association is the bylaws of a company, meaning the article are the internal regulations of the company on the basis of which its internal affairs are managed. They lay down the powers of the directors, shareholders, and officers. It is not compulsory for the public company to prepare its own article of the association. It can follow table A of the Companies Act, where the preparation of the article of association is compulsory for the private company. The article of association, the following are the contents of the article of association: share capitals and variation of rights, exercise of lien by the company, calls on shares, transfer, transmission, forfeiture and surrender of the shares, issues of the shares warrants, alteration and reduction of capital, voting powers of members, borrowing powers, proceeding at the board and in general body meetings, appointment powers, duties, qualifications, remuneration, etc. of the directors, appointment of manager, managing director and secretary, dividends and reserves, maintenance of books of accountants and their audit, the company's seal, winding up these or contents of the article of association. If we talk about the registration of the articles, there may be in case of company limited by shares and share in there shall in the cases of company limited by the guarantee or unlimited company be registered within the memorandum article of association signed by the subscribers to the memorandum and setting out the regulations for the company. Article of association of a company limited by shares may adopt all or of the regulations contained in table A in the first schedule to this act. In this case of the unlimited company or a company limited by guarantee, the articles, if the company has shares capital, shall state the amount of share capitals which the company purpose of this registered in the article of association. In case of the unlimited company or a company limited by a guarantee, if company has no share capitals, articles shall state under the number of members which the company purpose to be registered. In case of company limited by the shares registered after the commencement of the act, articles are not registered if the articles are registered in so far as the articles do not exclude or modify the regulations in table A in the first schedule of the act. Those regulations are so far applicable by the regulations of the company in the same manner and so same extent as they are the contained in registered articles. The articles of every company shall be explicit and without the ambiguity and without prejudice. The generality of the foregoing shall be listed, enumerate the voting, other rights, and attach of the different clauses of the shares, other securities, if any, issued by it. If company contravenes the provision of this article of association, the company and every officers of the company shall be liable to a penalty with exceeding of the level 1 on the standard scale. Articles to be printed, signed and dated. The articles shall be printed in the manner generally acceptable, divided into paragraphs, numbers consecutively, signed by each subscriber, who shall add his present name in full, his occupation, 10. Nationality, usual resident address and residential address, and such other particulars as may be specified in the presence of the witness, who shall attest the signature and shall likewise and his particulars and date it. Article alteration of the articles, if we want to alteration changes, then the section 38 defines, subject to the provisions of this act and the conditions contained in the memorandum, a company may be special resolution alter in article, and alterations so may be shall valid if originally contained in the articles and subject to the like manner to the alteration by a special resolution. If the alteration is passed by the special resolution, then it will be considered good, provided that where such alteration affect the substantive right or liabilities of the members of a class of members, it shall be carried out only of the majority of at least three-fourths of the members of the class of members affected by the such alteration, as case may be exercise the options to vote personally or truly proxy vote for such alteration, which means that alteration by resolution and resolution by the voting. A company of the Articles Association as altered shall within 3 days from the date of passing of the resolution be filed by the company with the registered and shall be registered by the same, and therefore for the articles so filed shall be articles of the company. Copies of the memorandum and articles to be given to members. Okay, memorandum and article of copies will be given to the all members. Each company shall send to every member as it requests within the 14 days thereof on payment on such sum as a company may fix a company memorandum and article. If any company make default in copying in complying with this requirement of subsection 1, it shall be liable to a penalty not exceeding level 1 of the standard scale. Alteration of the memorandum of article to be noted in every copy. Where an alteration is made in the memorandum or articles of a copy, every copy of the memorandum or articles issued after the date of the alteration shall convert to the memorandum or articles as so altered. If the alteration is made, then it must be included in the article and memorandum of association. If wherein such alteration has been made, the company at any time after the date of alteration issues any copies of the memorandum or article which do not confer to memorandum or article as so altered, it shall be liable to a penalty not exceeding of level 1 of the standard scale. Each company so issued and every officers of the company who is in default shall be liable the like penalty. Form of the memorandum and articles. The form of memorandum of association of a company limited by shares. Memorandum and article of association limited by guarantee and not having shares capital. Memorandum and article of association of a company limited by guarantee having a shares capital, and memorandum and articles of association of an unlimited company having share capital shall be respectively in accordance with the forms out in table B, C, D, and E in the first schedule as near thereof the circumstances admit. Licensing of the association with the charitable and not by profit object. Section 42. Section 42. Licensing of associations with charitable and non-profit object, where it is proved the satisfaction of the commission that an association to be formed as a limited company for promoting commerce, arts, science, religion, health, education, research, sports, protection of the environment, social welfare, charity, and other any useful objects. Such company intends to comply the company's profit and other income in promoting its object, and it prohibits the payment of the dividends of the company's members, and such company's object and activities are not to shall be any crime against the laws, public order, security, sovereignty, and other and national interest of Pakistan. The commission may be licensed for a period of specified, permit the association to be registered as a public limited company without addition of the word limited or the expression guaranteed limited to be its name. A license under subsection 1 may be granted section granted on such conditions and subject to the regulations as the Commission thinks fit, and those conditions shall be inserted in and deemed part of the memorandum and articles in of this document. Memorandum and article of association of a company licensed under this section shall be accordance with the form set out in table F in the first schedule or as near there or circumstances admit and approved by the Commission. The association registered under this section shall enjoy all the privileges and subject to all obligations of a limited company. The commissions may at any time, by order inviting, revoke license granted under subsection 1, which is the direction as it deemed fit or being satisfied that the company or management has failed to comply any terms or conditions subject to license is granted, any of the requirements is specified or regulations under this section are not made complied with. Affairs of the company conducted in manners prejudicial to the public interest, the company has made default in filing the registered financial statement and annual return for the immediately preceding which consecutive financial years. Or the company has acted against the interest, sovereignty and integrity of Pakistan, the security of state and friendly relations with foreign state. The number of members is reduced below 3 or the company is compliant or brought forth for it has a carrying unlawful fraudulent activities or run and managed by the persons who fail to maintain proper true accounts on the commit fraud, misfeasance or malfeasance in relation to the company, run and managed by a person who are involved in terrorist financing or money laundering, or managed by a person who refused to act in accordance with the requirement of the Memorandum and Article of Association provision with this act or fail to carry out the directions of the decision of the Commission or the registered company and the registrar given in exercise the powers conferred by this act. Not carrying in its business is not operation 1 year or it just the equitable, the license should be revoked. Provided that before the license is revoked, the Commission shall given to the company notice in writing in its intentions and do so shall afford the company an opportunity to be heard. Notwithstanding anything contained in this Act or any other law, no association shall be registered as a company by the objects unmentioned clause A and conditions provided in clause B subsection without a license granted pursuant of this section. Effect of the license on revocation of the licensed company under Section 42 by the Commission, the company shall stop all activities except recovery of money earned, if any. The company shall not solicit or receive the donation from any source, and all the assets of a company after satisfaction of our debts and liabilities shall in the member as may be specified and transfer to any other company licensed under Section 42, preferable having similar or extendable period may be allowed by the Commission, provided the reasonable amount of expenses of the voluntary winding up or making up an application to the register or striking name of the company of the register in terms of Section 3 may be retained by the company after the compliance of the requirement mentioned in subsection board. The company files within 15 days for date such compliance a report to a registered containing such information and supported with such document as to be specified. Within the 13 days of the acceptance of the report, registrar submitted by the company under the subsection 2 board shall initiate necessary proceeding for winding up of the company voluntary or where it has assets or liabilities make an application to the registrar for striking the name of the company of the registrar. The company fails to comply with of the requirements of this section, period specified such extent may be allowed commission of the commissions without prejudice of any action appoint administer and manage and subject to the terms and conditions may be specified in order and initiate necessary proceeding for winding up of the company. The provision 291 except those sections shall apply in mutated lieutenants or administrative appointment under this section. Where any assets of the companies are transferred in consequences of revocation of license to another company license under 42. Under Section 42, the members and officers of first mentioned company and their family members shall not be eligible to hold any office in later company for a period of 5 years from date of transfer of such assets. Where the license of the company has been revoked before the commencement of this act and such company is not process of winding up, this section shall apply if license was revoked immediately after the commencement of this act. If we talk about the finality, section 44 deals with the if a company licensed under section 42 or any of the officers make default in complying with any of the Requirements of Section 42, 43 rules, regulations, or terms or conditions which license is subjects and directions contained in revocation order, it shall without prejudice to any action shall be punishable by the penalty not exceeding of level 2 on the 36 standard scale. Provisions limited by guarantee. A company limited by guarantee may have share capital in case of company limited by guarantee and not having share capital and the provisions in this memorandum and articles in the constitution of a company purporting to give any person a right to participate in the dividend profits of the company otherwise than a member shall be void. For the purpose of the provisions of this act relating to the memorandum of the company limited by guarantee or subsection every provisions of the memorandum articles or any resolution of a company limited by guarantee purporting of divide undertaking the company into shares or interest shall be treated as a provision for such shares notwithstanding the nominal amount or the number of the shares of the interest is not mentioned thereby. Difference we already have discussed.